The nation's highest court steps in to rule on California's controversial policy giving transgender students privacy. The latest decision clears the path for California schools to tell their parents if their kids identify as transgender without the student's approval. KCRA 3's Michelle Bandor is live for us at the Capitol with reaction from both sides.
Well, Curtis, the U.S. Supreme Court ruling blocks, at least for now, a state law that bans schools telling parents if their child changes their pronouns or their gender expression while at school. The court's opinion was handed down without oral arguments from lawyers, and taking it up while the case is still sitting in an appellate court in San Francisco. So this all stems from when religious parents and educators challenged school policies that would prevent schools from basically outing students to their families. Some lawmakers argued that students have the right to privacy about their gender identity, especially if they fear rejection from their families. The case is currently sitting in a lower appellate court, but the high court majority stepped in, sided with the parents, and reinstated a lower court order blocking the law and school policies, all the while this case continues. Now, we caught up with the California Family Council and the chair of the California Legislative LGBTQ Caucus to get reaction.
We are overjoyed. We've been arguing for years that it's wrong to keep secrets from parents, and that's been the state policy here in California, that they have the right to keep the name and pronoun changes that happen at school secret from parents. And parents have parental rights, and changing someone's name is a significant thing. You have to get permission to, take an aspirin, at school from a parent. How can you change their name and parents be kept in the dark?
We are trying to make sure that local school boards, some of which had tried to pass what we call forced outing policies, requiring teachers to be able to report this information when it's not always safe to do so and not always in the best student's interest. Those conversations always and still could be between the parent and the youth, but teachers shouldn't be the gender police. That wasn't referenced in the Supreme Court shadow docket ruling. And so because of this really rushed decision, Justice Kagan had mentioned as well too in her dissent that this is a very exceptional and rare approach to be able to deal with this issue with no oral arguments, no actual real analysis, no deliberation, and that leaves us very confused about its applicability.
Yeah, and because the justices did not, there is some question sending a message to the lower court on how they should make their ruling. Reporting live from the state capitol, Michelle Bandor, KCRA 3.